I'm calling the planning board meeting, the January 9th planning board meeting to order at 6:01. Do I hear a motion to adopt the agenda?
I'll make a motion to adopt the agenda.
I'll second.
All those in favor?
Aye.
Okay, motion passed. We also need to approve the minutes, so I would like a motion to approve the minutes of December 12th.
Motion to approve the minutes of December 12th.
I'll second.
All those in favor?
Aye.
Okay. Next, we can move on to the organization rules and procedure. Would I like to go ahead and make a motion and then start the discussion, or are you
Have the
going to
discussion
discuss?
first. Yeah.
Okay, let's move on to discussion then. Thank you.
Great, thank you very much. A few months ago, I had ordered suggested rules, procedural rules for local appointed boards, and it's by Trey Allen and A. Fleming Bell III. This booklet is published by the UNC School of Government, specifically for local appointed boards, i.e., Planning Board, Board of Adjustment. And it's based on Robert's Rules. The latest edition of Robert's Rules was released in September of 2020. And so you might ask, especially if you're new, well, why do we use Robert's Rules? Why do we have parliamentary procedures? And so one is to formally move the business that the planning board has onto out front to where that you can discuss it, take action on it in an orderly fashion. And it also provides a framework for fairness and openness, to where that anyone that has a comment to make, even if you're in the minority of an opinion, you have the opportunity to make your statement. And but it'll still be the majority that decides on the recommendation. And it's essential to understand the basic rules of Robert's Rules of Order. They can be quite complex, and it might take some, to me, it takes some mental gymnastics for people that really know Robert's Rules very well, and they use them very well in debate. I don't think we've ever gotten to that point. It's generally, make a motion, second, and you have a discussion, and whatnot. Ours is a little bit more simplistic, but at the same time, it gives that framework, and it gives the opportunity for everyone to discuss items that come before you. So fair debate, and the other thing is that all votes are counted equally. And one of the differences between the Planning Board, Board of Aldermen, where the chair of the planning board gets to vote. And whether, it doesn't matter tie or not, but you still get a vote. For the Board of Aldermen, the mayor does not get to vote unless it's to break a tie. Let's see. So the Planning Board, Board of Adjustment have actually had rules of procedure since about 2007 for both of them, and then the intent is every May, once a year, that the planning board, Board of Adjustment, you review those rules of procedure to see if there are any changes that you would like to make on those. In prior editions, this one is a little bit different, I think. I think I did it, or I tend to do it that way, is we had to make amendments to the rules, excuse me, after Hurricane Florence, when this building was not available and the administration was displaced, and we were having meetings next door to the Pizza Hut, or we were having meetings, I don't know if the planning board did, but I know the Board of Aldermen did at St. Regis or at the fire station. It seemed like we had meetings everywhere but my kitchen table, right? So I think that the way that this is written, or hopefully it is, I'll have to double check on that we have an assigned meeting place, we have an assigned meeting time, and that schedule gets published January, December, or December, January, but preferably December for the upcoming year, and it gets published, right? And then it also provides guidance on if there's a change in that schedule and who can make that change, right? So have all of you had a chance? I know it was like 14 pages, and I know that it can be dry as sawdust. Did everybody have the opportunity to go through and read through those pages? So no, yes.
Yeah, I assumed it was similar to the previous one we handed out a couple of years ago.
Right. So basically, it's an update to include the 2020 Roberts rules. So there was one question. I'm glad that Chip is here with us. Hey, good afternoon, Chip. How are you doing? Can you hear me?
Sorry, yes, I had to.
There we go.
mic myself.
There you go.
Yes, I'm well, thank you.
All right. So there was one question, and I left it highlighted. Throughout the template that the UNC or that Fleming Bell and Trey Allen provide, they have some like little brackets where you can pick one or the other, or that you have some flexibility in there. And so how you have normally conducted business and how it has been in the past, I simply fix that for you, put it how we normally conduct business. But I did have one question that I wasn't sure about, and I left it highlighted under Rule 29, duty to vote. Fancy shades aren't going to help. I won't read that whole thing. Planning board may not excuse a member except in cases involving 1, a conflict of interest as defined by law or the planning board, or 2, the member's official conduct or own financial interest, the unexcused failure to vote by a member who is physically present in a meeting room or has withdrawn without being excused by a majority vote of the remaining members. Comment, like they give all the options, shall be recorded as an affirmative vote or a negative vote. So
Affirmative.
Affirmative, okay, great.
Yeah.
I thought,
And you'll get to this in your video, but all the motions are made in the affirmative, so it would be an affirmative vote.
okay. All right, I think that was the only question that I had on there. So if you've had a chance to read through them and you're comfortable with adopting them as presented with the correction and affirmative vote, then we can proceed. Chip, did you have a chance to review the draft rules of procedure?
I did, I thought they were very good.
Okay, and did you have any edits or any corrections to it?
I did, no, I thought they were very thorough.
All right.
Well done.
Excellent,
Deb,
thank
I
you.
have one question.
Okay.
Which is it's number, Rule 21. we normally do second every motion,
Yes.
but it says no second is required on any motion. Do we want to say that we second or stop seconding? Or,
It's not required, but we still do it.
Yeah. So where it's not required, Chip, the planning board wants to continue with seconding the motions. So on Rule 21, we could strike out not and say second required.
Yeah, I think that's appropriate.
And so the sentence would be, second is required on any motion.
And so
Yes.
the Rule 21 would be,
There's also, it's written somewhere else in here too.
Okay?
I can't remember exactly where it
Alright, I'll
said
look
it
for
was
that.
not required.
Okay, I'll look for that and make that change. So
My
second is.
question on that is, I always thought that in order for a motion to keep for discussion purposes, that you had to have a second, and then you went into discussion.
Right.
So, because if somebody makes a motion, and then there's no second, then the motion dies.
Correct.
So, I'm a little confused here by
By
that
the
even
change?
being an option
the
or
change?
the change, because then it sounds like any motion is in motion.
That you would have to vote on whatever motion was made, right?
Right.
And I think that would be.
So if one person is interested in a subject,
Right.
and say you have a panel of 7 or 8 people and nobody else is interested in it, you just still go on with discussion, and then, to me, it seems wasteful, time-wise. Am I making myself clear on that?
Yes.
I'm not sure.
Yeah. Well, I think if you, yeah, I think, and
aren't
I think
there,
that there, Robert's Rules of Order is a bit arcane, but it's the standard that a lot of folks work from. And what they do, what boards tend to do is take sections of it and amend it for their own uses. A lot of Robert's Rules you won't need. It deals with
yeah,
arcane parliamentary procedure that won't concern you. The idea of seconding a motion ordinarily in a parliamentary procedure situation is absolutely necessary. In a board like the planning board, I can understand why the authors of this may have suggested that it may not be required.
well,
I
some,
think as a matter of practice, it might be a good thing to do. But I don't think that, I think there's an argument to be made. I can see an argument about why, it might not be needed.
right. Well, there could be somewhere in the weeds, certain motions that don't require a second, and that may be what this is referring to, and
That
it
could
just got put into the text. Because, like I say, if you get way down into the weeds of it, there are probably some motions that don't require a second, and that may be what that's referring to. Well,
I would suggest to the board, I'm sorry, that whether you second or don't second a motion will not cause problems in court if the decision is challenged. It is more of a creature of parliamentary procedure rather than a legal necessity like a quorum
right.
or a vote in favor.
Yeah, I've
Thank
been
you.
at several meetings where, especially at the end where you adjourn, somebody makes a motion to adjourn, and then everybody just gets up and leaves, and you never really have a second sometimes, and, I can see something like that happen.
Yeah, there were a couple of sections. Motion 10 on page 13 is one where I took out and just put not applicable. And I did that to keep the numbers the same. And so if I didn't, for whatever reason, I just didn't want to change the numbers. And so if it referred to like referring an item to a committee, which is not something that the planning board would do, then I just put, not applicable on there. So, as we go through, if you find, and that's what amendments are for, once you vote to re-adopt this or to adopt these rules of procedure, then as we go on, or if your eye catches something that doesn't fit the planning board and how you want to conduct business, then all you have to do is bring it up at a meeting. We'll put it on the agenda and amend those rules. It's something that needs to be something that works for you, not something that you're handicapped by. But the basic foundations, and you use them automatically. This is just formalizing those rules, and also, having a chair, having a vice chair, and what the notification responsibilities are in the event of, if you have to cancel a meeting, what are the procedures, So it's just really just basic nuts and bolts organization. How do we traditionally conduct business? And certainly consistent with the rest of the localities, in the state, basically.
I had one question about closed sessions. I was always under the understanding when the group, usually it's been a city council or board of aldermen, come out of a closed session, they're required to give a brief of something about what happened in the closed session. And this says apparently you just continue your meeting. Am I misinterpreting what coming out of a closed session is?
No, all they have to do is, whenever they come out, state that no action was taken.
Right, but this doesn't even say that.
Yeah. Because you can't, I guess you can't take action during a closed meeting. So them saying we didn't take, no action taken is just kind of a confirmation that they were following the rules, that they did not take any action. So where it doesn't say anything and you come straight out, the presumption is that you didn't take any action. But for whatever reason, say if we went into closed session, and that was unusual for me. We haven't done that since this is something that's come up since we've had the new attorneys, where they've gone into closed session with you. And we did not have that in the previous rules. I'd taken it out because we never went into closed session. I did not foresee us going into closed session. So in those drafts, whenever I had it, I just took it out. So now that we have attorneys that want to brief the committees, and there's a need to consult with the attorney, that is certainly the one reason that you would have for going into closed session. Does that make sense? Mm-hmm. So now having it in the rules, leaving it in the rules, then it kind of, you're okay.
I just always thought you had to have something like, we discussed a personnel matter or something like that, and just leave it at that. Don't have to say what the personnel matter was, and then just continue with the meeting.
It's not that for the Board of Aldermen, and even for us, like if we were getting ready to go into closed session, at the beginning of it, you would have to announce, and I think there's like five reasons, something like that.
Yeah, there's about 9 or 10.
Yeah.
Yes, you're exactly
But
right.
why you're going into closed session? So the chair would say, the next item is closed session. We're going into closed session for, and then, cite the North Carolina General Statute, A, consultation with town attorney. So.
And it's usually on the agenda,
Yes, absolutely.
written on the agenda what it is.
Yeah. Yes.
Okay, I guess we can move on.
It's entirely up to you. If you are prepared to, if the consensus is to go ahead and adopt the procedural rules,
As
then,
amended?
then you can have somebody make a motion, if that's the consensus. It's entirely up to you.
Does anyone have any concerns that they'd like to bring forward? Okay. I'd like to hear a motion then to approve the updated rules and procedure as amended.
Move to accept the document as printed.
Okay. All those in favor?
Do we want to make those two changes?
And he said as printed, but.
As
you
amended,
meant-
made.
As discussed and amended.
And so the changes were,
Affirmative, and that we
Rule-
do want a second.
Rule 21, second required, second is required on any motion.
And the other change was
And,
Rule 29, wasn't it?
yeah,
Where it is an
yes.
affirmative vote.
Yes, thank you.
And just to be nitpicky, he said accept, should we not use the word approve? Or does it not matter?
Oh, what does the town attorney say?
Approve.
Approve, okay.
I think it's 6-1, half dozen on the other, but approve's probably good.
What change the
Okay.
motion?
We want to clean up that motion.
I move we accept
Approve.
approved the changes and amendments to the procedures.
Okay. Any more discussion? Okay. All those in favor? Aye. Thank you. Motion passed.
Very cool. The two new guys made the motion in the second. Very cool.
Yay.
I like that.
All right, we're down to public comment. And I'm guessing that there's no public comment as we don't have an audience physically in front of us. Anyway, we'll move on to discussion. American Planning Association presentation video, legal decision making.
And we're going to talk about the legal aspects of decision-making related to the planning commission. So, Greg, thanks for joining us. Thanks for having us. So let's start with just that. What are the legal implications of a plan commission recommendation? How cautious do they have to be? Do they need to pay attention to any legal precedent, or start us off with that?
Sure. Well, at its heart, a plan commission is supposed to conduct a thorough public vetting of a development proposal or anything that comes before it, and make a recommendation to the city council or the village board, whichever municipality it may be. So the recommendation matters, and the conduct of the hearing matters, because in theory, the facts and testimony provided at the hearing will provide the basis for the plan commission's recommendation. Plan commission needs to allow as many people or interested parties to speak at the public hearing as possible, because you want to make sure you have a well-rounded, full body of evidence to make a recommendation on. And village boards and city councils tend to pay attention to plan commissioners. The mayor appoints a plan commissioner, and they're typically confirmed by the city council, so they've placed trust in them. There's an expectation that they will go ahead and do their job thoroughly and diligently. So the recommendation absolutely matters.
Okay, so, but for the commission, they don't have to worry too much about the city getting sued, if they're doing their job, if they're going through the process correctly, and ultimately, there's an elected body behind them that's making the final decision.
That's right. The commission needs to stay focused on the standards for approval for the request in front of it. So what does that mean? That's, if there's a variance request, the zoning code will have specific standards that the plan commission should consider when determining whether to support or recommend denial of a variance. There's different standards for special use. Planned unit developments typically have much longer standards because it's a more involved process. So as long as the Plan Commission views the testimony that's provided at the hearing through the lens of those standards to determine whether or not the applicant is meeting those standards, the city's pretty well protected from a lawsuit.
Well, one of the questions we get a lot from commissions and commissioners in the work we do is they're always worried about setting a precedent. So if we allow this variation or approve that special use, haven't we set a precedent that allows the next one to come through that maybe we don't like, we can't say no to it? Tell us a little bit about precedent.
There's a lot of misconception around the concept of setting a precedent. The short answer is if you approve a fence variance for Joe Jackson, you're not required to go ahead and approve the next fence variance that comes in for Sally Smith. Each request should be evaluated on its own merits, its own facts, and its own circumstances. So we'll take Joe Jackson's fence variance request. Say he comes in and asks to build an 8-foot fence in a zoning district where only 6-foot fences are allowed. Maybe that 8-foot fence is warranted because there's a drive-through on the property next door, or there's an alley next door, or there's a dog kennel next door. Now, when Sally Smith comes in, her house backs up to another residential property. So there's differences, factual differences between the two cases. So the way that a plan commission can really protect itself from arguments of, well, you approved Joe's variance, you have to approve Sally's variance, is to focus and drill down on the facts. If you focus on the facts and the testimony presented at the hearing, it should become apparent that there are differences between the two. Now, that's the legal answer. It's difficult to set a precedent by approving one variance. There's also the public perception or political angle as well. Now, the public is not necessarily going to understand the nuance between the two variance requests. And this also reemphasizes the importance of making sure you clearly state on the record why you're supporting the variance, what those facts are. That way when someone comes in later, you can say, yes, but you're not located next to a kennel or a drive-through or an alley that has a lot of traffic.
Okay, that's great. We talked a lot about findings of fact as part of the deliberation. First of all, what are they? And second of all, why are they important?
Findings of fact are, it's an analysis of the testimony and facts presented at the hearing. So it's all the reasons why, or in some cases why not, a proposal meets the zoning standards in the ordinance. It's important to note that the findings of fact need to be based only on the testimony provided at the hearing or the meeting. You're not supposed to take into account any outside factors that haven't been presented on the record. So they're important because it shows that the Plan Commission is doing its job and it's considering the appropriate legal factors when it makes its recommendation. So the Plan Commissioners, again, this is going to be a common theme that runs throughout our talk. They need to be familiar with the standards and they need to view all testimony that's provided at the hearing through those standards. And it's pretty common for commissioners to actually have the standards written down on the dais next to them, and that's part of having a quality staff report as well.
And in terms of those findings of fact, they ultimately become part of the record. They ultimately find their way to the elected body that's making the decision. Who writes them? Staff, secretary, chair of the commission, somebody randomly selected from the commission?
It varies, and a lot of it depends on the capacity of the municipality, both in terms of how much staff support they have, and things of that nature. So there's three common approaches. First, it's a really good idea to have the applicant submit draft findings of fact with his application. The applicant, at the end of the day, is the one asking for approval. He's asking for relief. Have him make his case in writing. And that serves a couple of purposes. First, it'll provide the commission with a general idea of what findings of fact may be if they wanted to support the case. And two, it'll help get the applicant in the right mindset before the hearing, because it's basically his presentation or his argument written down, which is good. It'll make for a more fruitful hearing. It'll get him focused on those standards as well. Alternately, the commission can draft its own findings. That can happen during the meeting. Certainly work with clients that have worksheets, basically, that have here's standard number 1, and there's 5 or 6 lines below it, and the commission, after the public hearing is closed, still during an open meeting, will discuss what facts and what testimony presented at the hearing satisfy that factor, and they'll walk through all of them. And that's a little bit more labor intensive. It can make the meeting a bit longer, but on the other hand, it also helps show the public how the sausage is made, so to speak. You know, it's very transparent. It's very apparent what the commission is doing. There's no activity behind closed doors. Or alternately, if it's a community with more resources, you can have staff prepare findings, either draft findings prior to the hearing or findings based on the testimony after the hearing. So there's no one right way to do it. If you have staff, they're typically the professionals, the experts. It's great to rely on them. We certainly recognize that not every community has a professional planner on staff.
But those findings written around those standards, those are really kind of the heart of the evaluation of the testimony process, aren't they?
They absolutely are, and they'll be forwarded on to the city council for their consideration prior to the vote. Certainly, if you end up in court, the findings made by the Plan Commission are a consideration. So it's important, and you should take time with them.
So you mentioned, we talked about that there are standards that these findings of fact address, and that sometimes there's more of them. They're generally similar, they're not the same in every community, but sometimes you can say there's a lot of them for plan unit development, there might be more of them. Does the application have to meet all of these standards, or just most of them?
The application needs to meet the standards. It's not 1 out of 3 or 2 out of 3. It's not more than not. It's clear that the application needs to address each standard. So that's part of the burden that applicants carry, and that's why they need to be carefully consider the application they're bringing forth and whether or not they can state a claim, substantiate support for that proposal.
Aren't some of those standards written where there's some room for interpretation? I mean, those standards are not, is the building 6 feet tall? Those standards talk about there's adequate facilities or there's adequate capacity, and there may be something about impact or trend of development. Those might be kind of fuzzy things. Is that true? And what if you can make a case the other way?
Yeah, there's absolutely room for argument, and that's why we have attorneys. They're not yes or no answers in many cases. It's a lot of analysis based on the facts and circumstances related to the property, which is what this is supposed to be about. It's a hearing about what's going on the property.
So with that in mind, what should a commissioner keep in mind to be sure that as they're either asking questions or making their comments or deliberating amongst themselves, what should the commissioners keep in mind so that they're making a good case, that they're helping form those findings of fact to all those standards?
Well, first, and this is probably one of the more difficult things for commissioners to do, is you need to be able to discern between relevant testimony and facts and what we'll call all the other noise. Some of it's obvious. Personal attacks obviously have no place at a public hearing. But there are a lot of other things that fall into a gray area where the commission, especially if it's not a particularly experienced one, may place a false emphasis on it. So an example of this. I participated in a hearing where there was a drugstore that wanted to move into a neighborhood. It was adjacent to a park, and it was predominantly a single-family residential area around there. There was a member of the public who stood up and testified, and she had, through the Freedom of Information Act, obtained copies of police reports for a drugstore located in a different community, not even the same drugstore. And she proceeded to read pages and pages, and this was years of police reports, talking about how children were going to be kidnapped out of the parking lot of this drugstore, and how rapists and pedophiles tended to frequent pharmacy parking lots. That's not relevant. That's totally irrelevant. And it's important for the Plan Commission to recognize that, and that also emphasizes the importance of having a chair that has a pretty strong handle on meeting conduct, because in that case, she was gavelled quiet and said, listen, if you have testimony that relates to the factors that the Plan Commission is required to consider, please provide that, but recognize that what you're talking about right now is not necessarily relevant. So the best advice really is to be familiar with those standards and view the testimony through the lens of those.
You mentioned gaveling a resident who's making a comment. And in terms of taking testimony and how much testimony and cutting off testimony, is there a legal answer to the question of how much testimony is enough, how much is too much, when can you cut people off, should you cut people off?
Generally err on the side of providing more testimony. It's painful. It can make for some long nights. You're going to see your family less, but that's your job. The City Council has the ability to curtail public comment largely out of necessity. They're governing the entire municipality. The Plan Commission's purpose is different. They're there to take testimony. They're there to listen to a wide range of claims, some more relevant than others, some clearly irrelevant. They don't have to listen to those. But if there's a degree of relevancy in what is being presented, the Plan Commission's obligated to listen. And that serves the purpose of making sure they're doing a thorough job, evaluating each proposal and giving it the time that it deserves. And it also protects the community, the city, from lawsuits in the future, that someone's due process rights were cut off. Folks have a right to be heard. That's why we have public notice requirements. That's why we have open meetings. And that's kind of the bedrock principle of democratic government.
Okay, that's great. So that's just part of the process.
Yes.
In terms of the operations of a commission or a plan commission, I know a lot of them have got their own bylaws, their own set of rules and procedures. Is that a requirement? Do they have to have those? And if they don't, is it a good idea to have them?
It's a good idea to have them, and laws can vary, do vary, I should say, from state to state. The bylaws are important because it's really the playbook for how the Plan Commission is supposed to function. So it talks about membership, it talks about obligation to attend meetings, it talks about conduct of meetings. A variant of Robert's Rules of Order is commonly used by a lot of Plan Commissions, but you don't have to use Robert's Rules of Order wholesale. You can make changes. It's really a good idea because Robert's Rules of Order is really intended to govern deliberative bodies that are in constant session. And Plan Commissions aren't. They hold a meeting once or twice a month and they're done. So the bylaws establish the ground rules. They can establish limits within reason on public comment as well. So if the situation comes up where the Plan Commission needs to limit public comment, and there are bylaws that have been adopted by the community, that's a stronger legal position if you ever need to defend it.
It sounds to me like a lot of these rules, a lot of this structure really is ultimately to the benefit of the commission. So that if you have a bylaw rule that says, we're going to try and end the meeting by 11 o'clock, or we're not going to start a new case after a certain time, and that you've got to stick with these findings of fact and consider those, that this structure can really be very helpful to the staff and the commission in managing what can be an emotional situation.
That's exactly right. It's the rules of the road, and it establishes expectations. And to your comment about ending meetings at a certain time, we've all been in situations where we've sat through the small hours of the morning listening to deliberations for commissioners who have been on the dais for 5, 6, 7, 8 hours, and it's hard to make good decisions when you've been sitting up there and it's 2 o'clock in the morning.
From a legal perspective, you might not make the best decision.
I would agree with that.
So the motion, the way motions are made, a lot of times you see commissioners get a little bit hung up in how they do this. One of the key understandings, though, is that motions are always supposed to be made in the affirmative. Is that right? And tell us why.
Yeah, that's correct. And an example will help highlight why or how this can go wrong, because it can go very wrong. So imagine you've got a controversial land use proposal. Say it's a glue factory. It's loud, it's noisy, it smells, and they want to locate next to a park in the middle of a residential neighborhood. So, basically the least consistent land use you can imagine with children playing in the property next door in the backyard. And at some point during the hearing, it becomes very apparent that everyone in the audience is opposed to this other than the applicant. And one of the commissioners is just fed up, and he's, in a moment of passion says, you know what, I'm going to make a motion that we deny this proposal. So, and the motion's seconded. So the motion on the floor is now a motion to deny. So it's in the negative. So the roll is called, and everyone starts voting. Those voting yes on that motion are voting to kill the proposal. Those voting no on that motion are voting to support it. Now, take a step back. Think about a referendum question, or anytime you step into the ballot box. It says, Michael, do you support a tax increase to pay for constructing a new village hall? Your yes vote means yes. In the circumstance of this plan commission that just stated a negative motion, your yes vote would mean no. So that's confusing, and it also confuses the folks in the audience who are sitting there watching an entire dais of people vote yes to kill a project. And this goes on. It's not just an immediate concern, because the meeting minutes, from a legal perspective, when something goes wrong and there is a lawsuit later, the minutes are very important. It's frequently the only copy of the record, what happened at the hearing. And the minutes can be very confusing when it says motion to deny, and it says who voted yes, and you've got yeses, and you've got no's. I've seen circumstances too where you've had a negative motion stated, and a commissioner's realized after the fact, either at that meeting or a subsequent meeting, saying, hey, I meant to vote the other way. So then you've got another procedural hurdle, and it not only confuses the plan commission, it makes the community look bad and disorganized in certain respects. You want to come across as looking professional. So all of this is easily dispatched by just stating motions in the positive. So even if you hate the glue factory, you make a motion to approve the glue factory and let everybody vote no.
All set. Okay. That glue factory, now let's take something that could get approved, may have some conditions placed on it as part of the approval. And what we see is that sometimes conditions are things that get talked about. So one of the commissioners might say, we need better landscaping over there. But that's not part of the motion, it's not part of the approval, it might be in the minutes. But ultimately that notion of, hey, we need more landscaping, that's not really binding. It's only binding if it's done how?
If you want it to be binding, it needs to be in the motion.
Okay.
And it will only be binding if the village board adopts an ordinance that expressly includes that condition. So if you feel strongly as a commissioner about a specific item, whether it's landscaping or the color of the building or signage or what have you, your motion to approve the development should state, I make a motion to approve the development subject to Bob the builder painting his building purple. Otherwise, it's not legally enforceable. Otherwise, the public who attended the meeting and heard the commissioner speak about the purple building will likely think that the building's supposed to be purple and will probably end up calling Village Hall when it ends up being painted yellow.
I think a lot of planners have been in a situation where a meeting had to be changed or rescheduled or a case removed because public notice was not properly made. So there are these legal terms that we hear a lot. We hear about public notice and open meetings, and they seem to just be very controlling in what goes on. Can you explain those concepts a little and why it really is important to pay attention to those?
Sure. This is the public process is quite possibly the most important component of the entire zoning review. Government's credibility is largely reliant on how responsive and accountable it is to the public. And the zoning process in Illinois and elsewhere requires open public hearings to be conducted for zoning proposals. This provides the public an opportunity to come out and express either their support or dissatisfaction with the proposal, and it allows a full record to be built. Without a public process, you get a lot of callous intrigue, frankly. Like there was a meeting behind closed doors, smoke-filled or not, and these decisions were made, and I didn't have an opportunity to speak, and that really contradicts what the basic principles of responsible government are. So in order to build credibility in government, in order to lend credibility to the decision that will ultimately be made by the city council, you need to have a big tent process where everyone's invited in and folks can come out and share their views about it.
So I want to turn a little bit to the legal elements of being a commissioner, things that the commissioners have to know. What kind of ethics rules are there that are bindings that are binding on commissioners?
Well, the ethics rules, that's a good question. And the ethics rules vary from state to state, but there's some certain common elements that run throughout them. For example, Illinois has what's commonly known as the Gift Ban Act. And it, as the name implies, prohibits commissioners from accepting gifts from prohibited sources. Now, I'm not going to sit here and lecture you on the specifics of the law and all of the elements because we don't have time and you don't have patience. But a lot of this is common sense. So an example, if you're a commissioner and someone who is before the commission, whether it's a developer or your neighbor who wants to get a variance to reduce his side yard setback, offers to buy you a new car or something expensive or anything really significant, and that seems out of the ordinary, you should probably think about it. So there's a couple important things to know here. Acknowledge that there are laws that govern conduct for plan commissioners. The typical plan commissioner is not going to spend time digging through statute books to understand what each of those laws are, but just know they're out there and exercise some common sense. B, as a commissioner, you're not an island unto yourself. You have a support network. Typically, there's staff. Typically, there's an attorney. If you find yourself in a situation where you don't feel comfortable or something doesn't smell right, talk to staff, talk to the attorney, and they'll provide you with counsel through it. It can be a little bit awkward in the moment when somebody offers you something and you say, hey, you know what, I really appreciate it, but I don't know if this is appropriate. I'm going to talk with staff. Let me get back to you. That's typically all it takes, and it can keep you out of trouble, and it can keep the community out of trouble too. Because what you really want to avoid is the specter of impropriety, because that can taint both the proceedings that are before the Plan Commission, whether it's a specific development proposal, and it can also implicate just the credibility of government in general. There's a lot of folks out there who think that government's on the take, and that's not the case in the vast majority of circumstances. But proceeding cautiously, understanding that there are laws that implicate your conduct, and realizing that you have resources that you can rely on will get you a long way.
Kind of related to that is the notion of a conflict of interest. So a lot of times you hear commissioners talk about, well, they have a conflict, or do they have a conflict, and sometimes they recuse themselves from a matter. So can you tell us what constitutes a conflict of interest and when somebody should recuse themselves?
Sure. The term conflict of interest gets bandied about, particularly in the public, more than it should. But there are situations where there are legitimate conflicts of interest, and commissioners should be aware of those situations. First, and an example will probably be most helpful here because the conflict statutes do vary from state to state. But take, for example, a plan commissioner who owns a property that's located next to a car dealer, luxury car dealer, big, beautiful cars. And the car dealer approaches the plan commissioner and says, hey, we're thinking about expanding our dealership. We're going to sell even more cars. This is great for the town, increased tax revenue. Everybody's going to be happy. We think you're going to love our beautiful dealership. There's glass windows and everything else. The commissioner says, yeah, that sounds great. So they enter into a purchase and sale agreement that's contingent on getting zoning approval. The developer then comes before the plan commission and asks for his rezoning in order to build his new dealership. The plan commissioner is sitting up on the dais. Does he have a conflict? It's a pretty obvious example. That absolutely is a conflict of interest. He has a contractual interest in the property that is part of the development proposal. So it's not okay for him to cast a vote on that. That undermines his ability to think in the public interest and keep the public interest and those zoning factors in mind. Because no matter how hard he tries, he's going to have that dollar value stuck in the back of his head that he wants to get for selling the property. That's a clear conflict of interest. Those situations, if they do come up, 9 times out of 10, probably more than 9 times out of 10, that commissioner is going to recuse himself. Those are pretty obvious. There are other situations which fall into more of a gray area. So, same example, but say there's no zoning contingency involved in the contract. Say the luxury dealer just buys the property outright and then comes back for approval a year or 18 months later. And that proposal comes before the plan commission, and that commissioner, who 18 months ago sold the property to the car dealer, is sitting up there. There's an open question as to whether or not it's okay for him to vote on it. In a lot of states, it's okay. There's not a contractual interest. So there's not a clear conflict of interest. That's the legal answer and the legal analysis based on the statute. But as a commissioner, you also have to keep in mind the optics and the appearance of impropriety. How would it look if a resident or the paper found out that that commissioner sold the property and then during the meeting was a vocal advocate for the development, and it ultimately went through and got approved? So there's a public perception component of it too. And just because there's not a legal conflict of interest, it's a good idea for commissioners to keep the public perception in mind. And if you think there's an issue, you can always recuse yourself. There's absolutely nothing wrong with that.
What about, there are times where people might think there's a conflict of interest, but there really isn't. So if the church you're part of is coming for a special use before you, or your country club comes before the commission, or if there's a rezoning for an entire zoning district in the downtown and you happen to own a property in the downtown, you're connected to it, but are those necessarily a conflict of interest?
Not necessarily. You really have to take a closer look. And this is where the public and sometimes, the media that's reporting on it can get it wrong. You end up with sensationalized headlines of, commissioner on the take, he's voting for his own self-interest. You really need to look at the specific facts and circumstances. Like an example that comes up frequently, say, Apple. Everybody loves Apple. An Apple store is coming to town. And Michael, you're a commissioner and you own Apple stock. And you know what? You voted to support that Apple store. That's not necessarily a conflict. Now, if you own 10% of Apple's stock, that probably would be a conflict because that's, I'm sorry to hear that. That would be pretty close to a controlling interest. But most people don't own 10% of Apple's stock. They own some shares and they have it set aside for retirement or what have you. So the facts are important and the analysis is important. And it never hurts too in these situations to state on the record, listen, I'm a parishioner of this church, but I'm not involved in the business management or affairs of this church, and I feel comfortable voting on it. And you might catch some flack from some people in the public, but a lot of them are going to appreciate that you've been upfront and you've explained your relationship and explained that there's no more palace intrigue going on here.
And I'll go back to the advice you gave with the last question we had about ethics, is if there's a question about a conflict of interest, contact your staff, contact your corporation counsel.
Always, always. And that's another really good point. I know a lot of communities don't have corporation counsel at the meetings, but they certainly can help, and this is one of the situations they can. There are legal issues that will come up that will inevitably be outside of the chairman or the commission's comfort zone, and having legal counsel there can really help you navigate those waters in the most sensitive of situations, a meeting that's televised or in front of a bunch of your neighbors and friends.
So one more thing about the commissioners that's got to be important because I think it's Latin. This idea of ex parte communication or talking to people outside of the meeting. Why is that an issue and what should be avoided there?
The whole purpose of the Plan Commission and the public meeting process is to have these deliberations in the public. There's nothing to hide here. Everything's up front. The decision, the recommendation that the Plan Commission makes is based only on the testimony and evidence presented at the hearing. So there's no hide the ball. Everything that you need to see is in front of you. Ex parte communications are when an applicant or an interested party lobbies a Plan Commissioner or City Councilman behind the scenes. So they invite you out for dinner, they show up at your door and say, hey, I bought you a cup of coffee, let's sit down and talk. Now, this is going to happen. You're a public official. A lot of these meetings are televised on TV in some communities. People are going to understand that you're serving your community, and that's a great thing. But as a result of them being aware of your service, they're going to go to you if they think there's an issue that you can help with. You're not going to go run and hide in the bushes. Or if you see Joe, your neighbor, coming down the street, you don't run across the street to avoid him. It's not realistic. But the best advice is you want to keep all of these discussions in the public. So if someone comes up to you and says, hey, I really want to talk to you about this development proposal, say, thanks, I really appreciate it, but as a Plan Commissioner, we're supposed to hold these hearings. Please come to the hearing. We'd love to hear what you have to say. That's the best way to make a difference, and your input really matters.
If you can't make it, send a letter perhaps or an email
Absolutely.
to staff.
Yeah, absolutely. And staff you bring up another good point with staff. Come to the meeting, or you can also direct folks to staff. Say, hey, if you have input about the proposal, staff's really managing this. They're doing the whole, the public input prior to the meeting. So, call, Sally the planner or send an email to this email address and give them your thoughts. Those thoughts will be shared with the commission, those thoughts will be shared with the city council, your voice will be heard. It just provides structure around the communication process, and it also provides a barrier protecting the commission from allegations that there's something nefarious going on.
Goes back to what you said before about the optics. It doesn't look like there's something going on. Everything's out front.
Yeah, exactly. And one last thought on this too. If you do happen to have a conversation with someone, and say it's a friend, and these conversations can happen. You start on one topic and you shift to another, and he brings up a relevant point about a development proposal that's before the commission. Disclose it during the public hearing. Say, hey, you know what? On Sunday, I had Joe over. We were watching the Bears game, and he brought up a point on this that I think is relevant, and I want to share it with the public. It tells them that the conversation happened. It puts it on the record. It shows that there's nothing to hide. So there are options to deal with it other than finding a bush to jump into.
And I think that's great advice, because I think a lot of times commissioners are uncomfortable with this idea of disclosure, letting people know what happened. But as we used to warn people, you don't want Joe to come and stand at the podium and go, hey, when I was talking to Commissioner Gregg about this the other day, he thought it was a fine idea. So it really, it's another one of these ways that the structure of the system really helps the commissioner, protects the commissioners, they do their job.
That's exactly right. It's being called out at a public hearing for a private conversation is definitely a red-faced moment.
Absolutely. All right, well, Greg, thank you for sharing your insights on the legal aspects of the commission function, and we thank you for your time.
It's been a pleasure. Thank you, Michael.
Thank you.
Is Chip still over there?
Is there any discussion about what we just saw? Anybody have any questions or concerns, comments?
Did you have anything that you wanted to add, Chip?
I watched it earlier today and I watched it again now. I thought it was very well done. I thought the focus for boards like the planning board on the standards before you, I thought was a very good thing to touch upon. I also thought the common sense approach to conflicts of interest was a good thing to raise. That's what Trey and I are here for. To answer questions. If something doesn't feel right, it's best to reach out early. And one of the things that he went over fairly quickly, but in my opinion and in my experience, the larger issue is the appearance of a conflict rather than the actual conflict. I think 7, 8 times out of 10, there's no conflict, but it sure looks like one. And that sometimes comes back to bite people. But no, I thought it was very informative. I thought it was a good thing to have the board watch.
I felt that it was very helpful as well in our small community, because conversations are going to happen if you're out in the community at all, and they do know who we are. I was surprised the other day when somebody said, well, yeah, you're on the board, the planning board. And I'm like, oh, I didn't even realize you knew that. Because I don't broadcast it usually. But anyway, I found it very helpful.
I know we've discussed this previously, Chip, and I don't remember if you were the attorney yet. The example I could think of is a couple of months ago, we had the issue with somebody that wanted to approve the pool in that area where there was 8 townhouses or whatever they were in there. And I know I went and thought it was on our agenda, and I drove by there just to see what the situation looked like. Is that something that you would recommend doing, or is that should be avoided, or what? How would you? Because it was just like, I was trying to say, well, let me just see what this looks like. But is that something that should be avoided?
Well, I mean, in my experience, site visits have been a fairly common practice. The issue becomes when you interact with someone. Anybody can view the site. It is the substance of the application. I don't recommend doing a deep dive into further information because you want to hear what the applicant has to say. I don't know what the practice of this particular board has been with site visits before. I'd defer to Deb probably on that.
Well, is in a situation where we only have one street going to where you live, and you have to pass the site. You can't.
It's hard to miss
Right.
it.
It's hard to miss it
Yes.
unless you could drive off the road.
Yeah, and that is part of the nature of being on a board in a small town. And you know, that can't cut against you because you do have to drive past it.
Right.
When you have an interaction with someone and allow them to bend your ear, that's when you have a choice there.
Right.
You don't really have a choice if you've got to drive past the site to try to get to where you're going. There's no way to really get around it.
So if the decision was, say, for a variance or public, if it was quasi judicial, then certainly at the beginning, if they were approached and there was a start of a conversation or whatever, then that would be a time where in the beginning interrogatories that the member could say, yes, I did go to the site, spoke with him briefly, let him know that, you know, I was on the board and that I didn't feel, you know, that I had to stop the conversation and just want to hear the facts at the meeting. And hopefully that's what is said. But typically, I have always encouraged planning board members, board of adjustment members to do a site visit, not to, you know, to drive by just to where, you know, put their eye on it to where that they get the grasp of what is being proposed. And I think that it may also help that whenever they go out there, that may spark some questions that when it comes to the actual application being presented, that they're able to ask those questions, and something that I may have missed or that, you know, I didn't think of. So I've got, you know, a whole panel of other individuals that are also looking at the application to see, okay, have they met all the requirements? Is there any conflict or any safety issue that has not been addressed? All right.
Yeah, I agree with that.
Any more discussion on anything anybody's concerned about? Okay. Could I get a motion on adjourning?
Make a motion to adjourn.
I'll second it.
All those in favor?
Aye.
Okay. Meeting adjourned at 7:04.
Great.
Have a good evening.
Thank
You too, Chip. Thank you.
Thank you.